Good morning, everyone. We're just getting ourselves situated here. We'll just be another minute or so um, before we start. But for the record, my name is Judge Frank Cavello in the Superior Court of New Jersey, Passaic County Vicinage. Today is February 10th, 2021, and we are about to begin a trial in the matter of Bonnet versus Stubbe. It is docket number L1843-18. And this is being conducted in Zoom virtual courtroom. It is a fully virtual jury trial, and it is being recorded in CourtSmart by our court clerk, Magda Gerges, who has confirmed that we're on the CourtSmart record. What we're going to do first is I will take the roll call of the jury in the jury room, and then we will come back out and I'll give my opening remarks to the jury. I just took the roll of the jurors. We have all 8 of our jurors present, and as soon as they are back with us, then we'll be able to begin. All right, I think that we are ready. Members of the jury, before we begin, I have a few preliminary instructions for you. As the jury in this case, you will be the judges of the facts, and you will be the only judges of the facts. You will have to decide what happened. I play no part in judging the facts. That's your responsibility. My role is to be the judge of the law. That is to say, I'll make whatever legal decisions have to be made during the course of the trial, and I will explain to you the legal principles that must guide you in your decision on those facts. You are to judge the facts in this case based upon the evidence presented to you and based only on the evidence. This evidence will consist of the testimony of the witnesses, the exhibits marked into evidence, and any material that is read to you. As the trier of fact, it will be your job to judge the believability of the witnesses, size up the witnesses. Does the witness know what he or she is talking about? How good is the witness's recollection? Is the witness accurate and correct in what he or she is saying? You may also consider the demeanor of the witness. That is, how the witness is behaving and how they're responding to the questions that are asked. You may believe a part of a witness's testimony and not believe other parts of it. During the trial, I'll be required to rule on the admission or rejection of evidence. You're to give no consideration to any evidence that I rule to be inadmissible, and you are not to speculate or guess what that evidence might have been or what it might have meant. Do not infer from any rulings that I make in this case or anything I say what my feelings might be about the outcome of the case. Even if you knew what my feelings were, you should disregard them, because it is your decision on the facts that controls, not mine. At the close of the entire case, I will explain to you the law which applies to this case. You must accept the law as I explain it to you and apply it to the facts as you find them to be based on the evidence. During the course of the trial, you'll hear from the attorneys on numerous occasions. Always bear in mind that the attorneys are not witnesses, and what they say is not evidence in the case, whether they're arguing, objecting, or asking questions. The attorneys are here as advocates and spokespersons for their clients' positions. This case is very important to all of the parties that are involved. They're entitled to the full attention of the jury throughout the trial and to fair and impartial consideration of the case by the jury. It is therefore important that you keep an open mind about this case until the very end when you're in the jury room deliberating. You're not to make any judgments or come to any conclusions about this case until you've heard the whole story. And that means until all the evidence is presented and I've explained the law to you. I also, at the outset, explained the importance of you being in a location where you would not be distracted, and where others weren't watching what you were doing. It's important that you not communicate with other people during the course of the trial or be engaged in any other activities, because the case is important and you must give it your full, undivided attention. You're not to have any contact or discussions with any of the parties, their attorneys, or any of the witnesses. You're not to discuss the case with anyone or permit anyone to discuss the case with you anywhere, whether it's in your home or elsewhere. You're not even to discuss the case with your fellow jurors until you're in the jury room at the end of the trial deliberating. If anyone attempts to discuss this case with you or attempts to influence your judgment about this case, you are to report that to me immediately. If you're to keep an open mind, you must not even discuss this case amongst yourselves until it's over and you're deliberating. That means when you convene each morning and you're in the jury breakout room at the beginning and during breaks during the course of the trial, you should not be discussing the case amongst yourselves. There are plenty other things that you can talk about amongst yourselves when you're in the jury breakout room. It shouldn't be about the case. Also, don't discuss the case with anyone who's not on the jury. This includes your family and friends. It's perfectly okay for you to tell your family that you've been selected as a juror in this virtual civil case and that the trial is expected to end today or tomorrow. You shouldn't tell them anything more about the case, though, even though a further explanation by you might begin innocently. Once you finish talking, the other person is not going to just stand there and say nothing. That person will say something, and whatever that response is may in some way influence your thinking. Your thinking should be influenced only by what you learn here in the virtual courtroom. So while this case is pending, you must not visit the scene of the accident because that area may have changed from the time of the accident until now. Additionally, as I've stated previously, you must not conduct any research or make any investigations on your own about the case. You are prohibited from conducting any investigation or research whatsoever because that's not your job. Your job is to decide the case based solely on the evidence presented to all of you here in the virtual courtroom. You must not investigate, research, review, or seek out information about the issues in the case, either specifically or generally. The parties, the attorneys, or the witnesses, either in traditional formats, such as newspapers, books, advertisements, television, radio broadcasts, magazines, through any research or inquiry on the internet, in any blog or any other computer, phone, text device, smartphone, tablet, or any other device. You must also not attempt to communicate with others about the case or even about the general subject matters raised during this case, either personally or through computers or cell phones or text messaging, instant messaging, blogs, Twitter, Facebook, personal electronic and media devices, or any other form of communication. You must not go on the internet, participate in or review any websites, internet chat rooms, or blogs. You must not seek out photographs, documents, or information of any kind that in any way relate to this case or the subject matter of this case. This prohibition includes any inquiry, search, or investigation of the facts of the case, the identities of the parties, the identities of the attorneys or the court personnel, news articles or reports, legal research, research regarding the subject matters discussed during the case, or even to look up in a dictionary or an online definition of a word, legal phrase, or medical phrase that's been used at the trial. I'll point out to you that you're going to get a glossary of medical terms when you go back to deliberate in the jury room. So there won't be a need for you to look anything up. You will only rely on the definitions that are provided by the court in this case. It's the job of the court to ensure that you're provided with all of the information and you're permitted to have in order to decide the case. So you might wonder, why is this restriction imposed? You are here to decide the case based solely on the evidence or lack of evidence that is presented in this virtual courtroom. You may wrongly be inclined to think that a different or additional information from other sources would be helpful to you, or that this prohibition is somehow artificial. Many of you regularly use the internet to do research or examine matters of interest to you. You may have seen information in the media that suggests to you that the type or quality of the information that you're being presented with in this particular case is not what you expected or what should be presented to you. This is not for you to determine. You must understand that any information you might access from sources outside of what's presented in this virtual courtroom is not evidence. One of the problems is that what you're examining may be wrong, incomplete, or inaccurate. That material may be outdated or may simply not be applicable to this particular case. And believe it or not, some things that you read on the internet aren't true. Indeed, there's often no way to determine whether the information that we obtain from other sources, such as the internet, is correct or has any relevance to the case. And there may be other reasons that certain information is not being presented to you, and it's not for you to question why that might be. Our system of justice requires that you, as a juror, not be influenced by any information outside of this virtual courtroom. Otherwise, your decision may be based on material which only you and none of your fellow jurors know. This would unfairly and adversely impact the judicial process. We must make certain that all of you hear the same evidence. And just as you must not obtain individually, you must not obtain any information from sources outside of the courtroom, the virtual courtroom, and share it with your fellow jurors. We must also make certain that each party has a fair opportunity to refute or explain evidence offered against him or her that may be unfavorable to their case. So please understand this clearly. If it is determined that any of you has violated this directive and conducted any type of research or investigation outside of this virtual courtroom, it may result in a mistrial, which would require this case to be tried again at great cost to the parties and to the judicial system, and it may lead to a penalty being imposed upon the person who violates this directive or fails to advise the court if another member of the jury has violated this directive. Although I will not prohibit you from taking notes during this trial, I am discouraging you from doing so. The concern is that note-taking would be distracting, that notes would often be incomplete, and that undue weight may be given to the notes. We want you to pay close attention to what the attorneys are saying in their opening statements and closing arguments, and to what the witnesses are saying in their testimony. If you're taking notes, you will not be looking at the screen and may miss important information, including nonverbal cues that help to assist in determining witness credibility. Additionally, we want you to rely on your combined recollection of all of the evidence. All right, so now I'm just going to outline for you the order of events. We will start with the attorney's opening statements. In their opening statements, the attorneys will explain to you the position of their clients in this litigation. They will tell you what they think this case is about and what they believe the evidence will show. The opening statements are designed to highlight for you the disagreements and factual differences between the parties in order to help you judge the significance of the evidence when it is presented. Once the attorneys have made their opening statements, then each party is given an opportunity to present its evidence. First, the plaintiff presents her evidence. Then the defense will present his evidence. Each witness will undergo direct examination, which means that the attorney calling the witness will ask that person questions. After that, the other attorney is given an opportunity to question the witness, which is referred to as cross-examination. Once all of the evidence has been presented, the attorneys will make their closing arguments. They will give you their analysis of what the evidence means and will attempt to highlight the significant evidence that is helpful to their clients' positions. Once the closing arguments are completed, I will instruct you on the legal principles to be followed when deciding this case. All right, so now it is time for us begin with the statements. So what I would ask that we spotlight the appropriate party for that. Mr. Fagundio will deliver his opening statement right now. Mr. Fagundio, you're muted.
Okay, I'm unmuted now.
Yes.
Okay, I'm sorry about that.
That's okay.
Technology. May it please the court and counsel, members of the jury, may it please you. This matter arises out of a motor vehicle accident that occurred on June 9, 2016. At that time, the plaintiff, Louis Bonet, had been working as a home health aide, caring for an individual that lived in Old Tappan, New Jersey. She had worked the evening shift that night, and she came off duty sometime around 6 or 6:30 in the morning. After her shift was over, she decided that she wanted to go home, obviously, and she drove from the patient's house into Rivervale, New Jersey. She came to a stoplight, and it was a red light, and when she came to that light, she stopped, and she was stopped there for a short period of time, when suddenly she was hit from behind by a vehicle driven by the defendant, Mr. Stubbe. As a result of the impact, the plaintiff's, Miss Bonet's vehicle was pushed forward approximately 1 to 2 feet, maybe a little bit more. Her body was thrown about in the car. Her eyeglasses were thrown off her head. At that time, she was in pain. She injured her neck, her back, and her left foot. Mr. Stubbe came out of the vehicle, came over to her, asked if she was okay. Miss Bonet then called the police. The police came to the scene. They examined Miss Bonet at the scene and called an ambulance. She was taken by ambulance from the scene to Hackensack Hospital at their outpost located in, I believe it's Old Hook Road in Westwood, New Jersey. While at the hospital, the physicians there examined her. They tried to treat her injuries, and they performed some x-rays upon her. Thereafter, they discharged her with some pain medication. They told her that she should probably stay home from work for a few days, and if that she continued to have some pain, she should follow up with another physician. The next day, Miss Bonet woke up and she still had pain in her neck and her back and her left foot. This pain continued for several days after the accident happened. About a week after that, Miss Bonet was still in pain, and she continued to suffer from her injuries. And with the help of her husband, they found a doctor that was relatively close to her home in Paterson, New Jersey. She then went to Dr. Robert Evans, who's located on 726 Market Street in Paterson, New Jersey, for the treatment of her injuries. She came under his care approximately on June 20th, 2016, and he continued to treat her for her injuries until December 2016. During the course of her treatment, he performed various massages and adjustments and other orthopedic treatments upon her. And Miss Bonet treated for approximately 2 to 3 times a week for a 6-month period of time after the happening of the accident. During the course of her treatment with Dr. Evans, Dr. Evans referred Miss Bonet to a neurologist, Dr. Cola, who examined Miss Bonet approximately 2 times. She was also referred for an MRI study of her neck, and her back because her symptoms were persisting. She was seen at an MRI facility, and Dr. Robert Traflett read the MRI film at that facility. Now, in December 2016, Ms. Bonnet was discharged by Dr. Evans. And from that time until today, she still continues to suffer from pain in her lower back and her neck. She will tell you about what she is suffering from until today. She'll tell you about her limitations that she has. I believe she'll tell you that her left foot injury has healed and does not bother her anymore. I'm confident at the close of this evidence in this case, and we'll discuss the evidence of this case at our closing argument, because the documentary evidence you'll have access to that at that time. I'm confident at the close of this case, you will render a fair and reasonable award to compensate Ms. Bonnet for her injuries, because that's all we ask for, is for a fair and reasonable award. Thank you.
Thank you, Mr. Fagundio. Mr. Lavoie?
Thank you, Judge. Good morning, everybody. Again, my name is Jason Lavoie, and I'm the attorney for the defendant, Ryan Stubbe. Now, in normal times, pre-COVID, at this point, I would say thank you for serving as jurors and give you a little statement about how important your service is. But these are not normal times. We are all making history by doing this trial in a virtual format. And when I became an attorney years ago, I never thought I would actually say that, but here we are. Now, this trial won't be a long one, but you're definitely going to have a good story to tell people about how you were part of the first or one of the first civil jury trials, virtual trials in the state. One thing I want you to keep in mind, the plaintiff has the burden of proof in this case. The plaintiff has to prove each and every element of her claims. And this is not a formality. I want you to keep that in the back of your head as you listen to the testimony and you look at all the evidence. If the plaintiff does not meet her burden, she cannot recover any damages. You see, it's not enough to say that an accident happened. The law is clear. Just having an accident in and of itself doesn't meet the plaintiff's burden. You can't just walk into court and say you were injured and in an accident. In this trial, the plaintiff has to prove by a preponderance of the evidence, and that's a fancy legal term. I'll explain it more in a minute. That she sustained permanent injuries that were directly caused by this accident. Now, it's important not to forget, as the judge mentioned in his opening remarks, it's not what the attorneys say that matters. It's what you say at the end of the day that counts. So don't be swayed by what the attorneys say. You listen to the facts, you look at the evidence, and at the end, you get to make the determination based on what you think. And at the end of the case, the judge is going to instruct you on the law. And the way our law works, you have to decide this case based on the evidence presented, as opposed to any sympathy or emotion that you may feel for the plaintiff. And that can be difficult when you're hearing about accidents and alleged injuries, but that's what your job as a juror is, and that's the oath you took when you decided to be a juror. So you just heard me say a minute ago, preponderance of the evidence. Basically, it means that the plaintiff has to prove more likely than not that her permanent injuries were caused by this accident, as opposed to another event, which I'll talk about in a minute. Think of it like scales. At the end of the trial, the plaintiff has to have tipped the scale in her favor in order to meet her burden of proof. Now, on the other hand, the defendant, Ryan Stubbe, doesn't have the burden of proof. He doesn't have to prove anything. Now, in addition to proving that she got a permanent injury caused by this accident, the plaintiff has to prove it by what's called the objective credible medical evidence. So again, the judge is going to explain that at the end of the trial too. But basically, it just means that the plaintiff can't say she feels pain. That's not enough. That's subjective, right? It has to be proven by the objective credible medical evidence. So what does that mean? Let me try to kind of give you an example. A person could say to you that they're hot, they're cold, or they feel pain. Now, you can't see it, they can't prove it, but they're complaining of it. Those are subjective complaints. Now, if that same person said they had a broken bone and you saw the bone sticking out of their arm, let's say, that's an objective complaint and you can see that. That's what the plaintiff has to do in this case. She can't just tell you that her neck and back hurts or that she has pain. She has to prove it by the objective, credible medical evidence and prove that it was caused by this accident. So how would that work in this case? For example, the plaintiff, as you heard, went for some MRI exams. Now, the MRI in and of itself is considered an objective test because it shows you the current condition of the spine. But the MRI doesn't tell you how the plaintiff got that condition or how long that condition has existed for. The MRI is only a snapshot of a current condition. So that's what doctors are for. Now, in this case, the doctors aren't going to testify. But instead, you're going to get to read and look at the medical records and the reports that the doctors prepared. Now, the defense's position is that these alleged injuries were not caused by this accident, but they're the result of a natural process called degenerative disc disease. Now, if the doctors were here, they would explain what degenerative disc disease is much better than me or anybody else can. But you're going to get a chance to, again, look at the reports and to help you understand a little bit better some of the medical terminology. We're giving you, as the judge said, a glossary of terms, medical terms that everybody has agreed on. And one of those terms is degenerative disc disease. And so I hope that will help clarify exactly what that is. But basically, it's something that's not caused by trauma from a car accident. Let's talk about the facts of this case a little bit. As you already heard, this is a pretty common accident. Happens all around the world every day, many times. Ryan Stubbe's vehicle contacted the plaintiff's vehicle in the rear. Nothing complicated, but that's just the beginning of the story. I want to make it clear. Ryan Stubbe doesn't dispute how the accident happened. This case is about whether the plaintiff sustained permanent injuries caused by this accident. So remember, as a juror, you're the judge of the facts, and you get to decide. And one of the tools that are at your disposal is your common sense. And after listening to the testimony and looking at the evidence, all I ask is that you use your common sense to decide what actually happened and what the evidence supports. Based on all the evidence, I think you're going to come to the conclusion at the end of the day that Ryan Stubbe and this accident did not create or cause the plaintiff to sustain any permanent injuries from this accident. And when I say this accident, I want to show you what I'm talking about. Because that's going to help put everything into context as you go through this trial. And I'm going to attempt now to share my screen with you, and we'll see if this works. Okay, hopefully everybody can see that. Judge, can you see that?
Yes, it's up on the screen.
Okay, thank you. So ladies and gentlemen, this is a picture of the rear of the plaintiff's vehicle after the accident. And now you're going to see these photographs at various points throughout the trial and in your deliberations. So, you don't have to study it now. I just wanted to show you to give you a preview. That's another angle of the rear of the plaintiff's vehicle after this accident. This is the front of Ryan Stubbe's vehicle after the accident. And this is just another angle of the front of his vehicle. So that's the accident that this case is about. And again, you'll see these photos at various times during the trial, and you'll have them in your deliberations. Thank you very much. I look forward to talking to you in a little bit.
Thank you, Mr. Lavoie. Mr. Fagundio, are you ready to call your first witness?
Yes, Your Honor. I call Louis Bonnet.
Good morning, Ms. Bonnet. We're going to ask you to just unmute.
Nope. I'm going to have to go over there, Judge.
Okay, can you hear me?
Yes.
Okay. We'll wait for Mr. Fagundio to return to his desk. Okay, so I'd ask you to raise your right hand, please. Do you solemnly swear or affirm that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, true.
Okay. Now, you can put your hand down, Ms. Bonnet. Now that you are under oath, during your testimony, you must be alone in the room where you provide your testimony. You must also turn off other electronic devices except for the device that you use to provide your testimony today. So I am going to then ask you to certify. Are you currently, and will you remain in the room by yourself during your testimony?
Yes.
Is your cell phone or other electronic device that you are not using for this presentation powered off, and will it remain powered off?
Okay, let me back off.
Thank you.
Put it in silence. Okay.
Okay, the witness is sworn. Mr. Fagundio?
Thank you, Judge. Louis Mean, you must keep your voice up during this because you're very soft spoken and it may be difficult to hear you with the microphone on the computer.
Okay.
Okay, so speak a little bit louder, please.
Yes.
Okay, how old are you today?
How old I am?
Yes.
I'm 50.
Okay, and what's your full name?
Women Bonnet. Women was yet Bonnet.
Okay, and you're from Haiti, correct?
Yes.
And you came to the United States approximately 15 years old,
Yes.
15 years ago?
Yes.
And your English you understand everything that I say, correct?
Yes.
It's just that your spoken English isn't as great as it could be, right?
Yes.
Okay. Now, do you remember being involved in a motor vehicle accident that occurred on June 9, 2016?
Yes.
Okay. Can you tell me what happened in that motor vehicle accident?
I come from work in the morning time. I stop completely Riverville by the lie.
Okay.
After
Now, stop right there for a moment. Where had you been working that night?
where?
Yes.
Old Tapping Wood.
Okay. And what were you doing at that time? What was your job?
Home health aid.
Home health aide?
Yes.
Okay. And what time was your shift over that day?
What time? At 7.
Okay. And you were caring for a gentleman that lived in Old Tappan at that time? You were
Yes.
caring for a gentleman that was living in Old Tappan at that time?
Yes.
Okay. So you left, what time did you leave his house?
That day I leave at 6:45 because the person take over for me. He was coming earlier that day.
Okay. So then you left his house and you were driving to where?
To Patterson.
And that's where you live, right?
Yes.
Okay. Now bring me up to the scene of the incident. Tell me what happened.
I stopped in battle of the light from Riverville Road.
What color was the light?
Red.
Okay. How long were you stopped there?
Last 5 seconds.
Okay. What happened next?
But I feel I hit in my back, and
Okay.
now I in my car move in the front.
Okay. So you were hit from behind?
Yes.
Can you tell me how far forward your car was moved as a result of the impact?
Like 2 or 3 feet like that.
Okay. At the moment that you were hit from behind, were you completely stopped?
No, I move my car move after it finished to move it. I put my feet hard on the brake. It stopped.
Okay. But before you were hit, were you stopped?
Yeah, I was stopped. Completely
Okay.
stopped.
As a result of the impact, what happened to your body inside of the vehicle?
When I feel my car move. Then I can explain. I move in the front after the seatbelt turn me in the back like that.
Okay.
That's-
And what did any part of your body strike the inside of the car?
Please, can you say it again?
Yes. Did any part of your body hit the inside of the car?
Yes. When the seatbelt turn me back, I hit in the back. I hit my head like that at the back and my I can't explain that. Oh, it explain when the seatbelt turn me back
Okay.
in the back.
Okay. Did anything else happen inside the car?
And the inside the car,
Yeah.
no, just my glasses fell out
Okay. And where did they land?
at the front.
Okay. Did they land on the floor of the car?
Yes.
Okay. At that time, did you have any pain in any part of your body?
Yes.
Where?
And my left feet and my back and my neck.
Okay. What was wrong with your left foot, if you know?
No, because my feet hit on the front of the car.
Okay. Are you referring to the dashboard, underneath the dashboard?
Yes.
Okay. What did you feel in your left foot?
I feel it's some like want to work there fall in my feet.
Okay. What about your back? What did you feel in your back at that time?
I feel my back hurt. Now when the police come, I explain that to her.
Okay. What did you feel in your neck at that time?
I feel the same pain because when the car send me at the front, I come back. That's why I hit my back.
Okay.
I feel the same pain.
Okay. Now, after the accident occurred, what happened next?
The guy come in, he say, "Oh, ma'am, are you okay? I'm sorry. Can I call the police?" I say, "Yeah."
Okay.
Call the police. There's one. When the police come in, it wasn't one lady. She take my blood pressure. She said, "Oh, your blood pressure is so high. You have to go to the hospital right now." Now
Okay.
call the ambulance.
So what happened? Did the police help you or the ambulance crew help you out of the vehicle?
No, she asked me if I can go outside the vehicle. I say, okay. I take the seatbelt off. She opened the door and she let me out
And where did they take you?
to the hospital.
Do you remember which hospital that was?
I think it's at the Valley Hospital because I don't know the area, but the hospital, it was in Hackensack, Valley Hospital.
Hackensack, the one in in Westwood?
Yes.
Yeah. When you were brought to the hospital, what did the doctors do for you there?
Oh, he examined my back and my neck after he do X-ray for my feet.
Okay.
After he give me medication for the pain, and me don't go to work for 3 days.
All right, hold on right there, Mr. Lavoy.
No, Judge, I was just I couldn't unmute myself, so I was just trying to get the court's attention.
Okay. All right. I think we took care of that for you. Thank you.
Thank you.
I'm sorry, Miss Burnett. Mr. Fagundio?
Yeah, she's off my screen now. I had her pinned. Now she's unpinned. I can't find her. Hold on. Okay. Yeah, she's not spotlighted anymore on my screen.
If you go to speaker view, I think she will be.
Oh, okay, that works. No, didn't work. Hold on.
Because she is still spotlighted.
Yeah. Okay, I'm back. Okay, now I forget where I was at. You're at the hospital, correct?
Yes.
I think I asked you before. They X-rayed your left foot in the hospital?
Yes.
Did they X-ray any other parts of your body?
No.
No. And they treated, what parts of your body did they treat in the hospital at that time?
My neck and my back. After he said he gonna give me medication for the pain. He give me Motrin. He tell me to take it 2 times a day. Now I take it, but I finish all the bottle of the Motrin.
Okay, well, let's slow down. How long were you at the hospital for? If you remember.
Of no, for only one day I went to the hospital.
Okay, but how long were you there for? If you remember.
No,
Okay.
I don't remember.
Ultimately, you went home that night? You went home after the hospital?
Yes,
Okay, and how did you feel?
I still feel pain
Okay.
in my body.
Okay. Now, let's bring you to the next day, the day after the accident. How'd you feel the next day when you woke up?
I feel the same pain, but it was worse than the day I made the accident.
Okay. Did you go to work the next day?
No,
What about the second day after the accident?
no,
You did not go to work?
no,
What about the third day after the accident?
no.
Ultimately, did your pain continue in your
Yes,
neck and your back?
yes,
And at some point in time, did you go see a doctor by the name of Dr. Evans?
no,
At some point in time after the accident, did you go see Dr. Evans?
yes.
Okay. How'd you find out about Dr. Evans?
When I explained to my husband, my back still hurting me. Now he checked in the internet, he found him.
Okay. And his office is in Patterson,
Yes,
and it's not too far from your house?
it's not too close from my house, but it's not too far too.
But
in
it's in,
Upper Street.
but it's in the same town as you, right? Is that yes? I couldn't hear you.
It's in the same town. Yes.
Okay. Now, you went to Dr. Evans, and at the first visit, what did Dr. Evans do for you?
He do massage for me.
Okay. Did he do anything else that first time?
He have a little he make massage after he have a little machine. He give me massage with the machine with his hand.
And you told him all the complaints you had, correct?
Yes.
Okay. Now, that was in June 2016. Did you continue to treat with Dr. Evans after that?
Yes.
And do you know how long you treated with him?
It was in June to December.
Okay. And do you remember how many days per week you would go and see him?
Before it was 3 days a week. After it's 2 days a week.
Okay. So for a period of time, you treated with him for about 3 days per week, and then that was reduced to 2 days per week?
Yes.
Now, during your treatment with Dr. Evans, he referred you to Dr. Cola. Is that correct? The neurologist?
Yes.
And do you remember how many times you saw Dr. Cola?
Just one time because I scared for the I don't know the name.
Okay. And what did he tell you about when he examined you?
But when he do it for me, I was scared. After he say, okay, if you don't want to do it, I'm gonna call Dr. Evans. You have to do it. Yeah, that's right.
Okay. Now, at some point in time, were you referred to have an MRI study?
Yeah, I do the MRI first.
You did that earlier?
Yes.
Okay. And do you remember what parts of your body you had the MRI study performed on?
Can you say it again, please?
What part of your body did they do the MRI on, if you remember?
And in my back.
Okay. So they put you in the tube?
Yes.
Okay. Now, at some point in time in December, Dr. Evans discharged you, correct?
Yes.
Okay. How were you feeling when you were discharged by Dr. Evans?
But I still feel pain in my back. Now he say he can't stop me. Every night my kids do massage for me.
Okay. Well, I just want to bring you back to December 2016 when
Oh,
you were discharged. At that time, you still had complaints of pain in your neck and your back?
yes.
Okay. How was your left foot?
But it was okay.
So your left foot had healed by the time you were released by Dr. Evans?
I can't wear heels now.
Yeah, okay. So it doesn't, your left foot, I just want to be clear, your left foot's not bothering you anymore.
No.
Now, from the time you were released by Dr. Evans in December 2016 until today, do you still have pain in any area of your body?
Yes.
Okay, let's just break it down by body parts.
In my back, but my neck on the morning.
Okay, we'll just start. We'll go methodically. Let's talk about your neck first. Does
Okay.
your neck still bother you?
Little bit.
Okay.
But in the morning, when I wake up, I'm supposed to turn my neck a lot. After when I finish to take hot shower, I feel a little bit better.
Okay. Does that bother you every morning?
Every morning when I wake up.
Okay. Does it bother you all day long, or does that pain go away at some point in time?
It go at some point, but my back.
Okay. Does the pain in your neck interfere with any of your activities that you do on a daily basis?
Say it again?
Does the pain in your neck interfere with your physical activities?
No, not too much. But in the morning, is bad.
Okay. What about at night? Do you have any issues with your neck at night?
At night, no. When I wake up, I tell you.
Okay. And how long does that pain last for in the morning when you wake up?
But like 5, 6. But I'm supposed to make exercise with my neck. I supposed to make exercise after I feel it's going away a little bit. But
Okay.
when I take a shower, it stop.
Okay. Now let's talk about your back. How often does that bother you?
Every day is bother me. Sometimes it's worse, but sometimes it's bother me little bit. But I always drink Motrin. It helps me.
Okay. So there are some days where your back pain's worse than other days.
Yes.
Do you have that pain every day?
Yes, because the job I do right now, because I stand to do it. I can do it, but my back bother me. Sometimes I sit down, but I can't sit down in that kind of job. You know?
Okay. So how long does it bother you? Well, let me rephrase that. How long can you stand before your low back bothers you?
But like if I stand like 2, 3 hours, after it's bother me, I sit down a little bit.
Okay. And how does it bother you? Explain that.
How?
Yeah. How does it bother you? Can you explain what happens to you?
It's bother me a lot because that's why every night I pass castor oil, and my kids give me massage every night.
Okay. They've been doing that for you since the time of the accident?
But say it again, please.
I'll rephrase it. Have your kids been helping you by massaging your back since the time of the accident?
Before the accident? Oh,
No, after the accident.
yes.
Okay. How does your back pain hurt you every night?
Yes.
There's
Every
no.
work is bad me.
Say that again. I'm sorry, I didn't hear you.
I say every night when I finish to work, it's bad me.
Okay. And does it bother you until you go to sleep at night?
Yes.
does it interfere with your sleep at all?
Sometimes when I finish to take massage, I have to take 2 motion before I go to sleep.
Okay. Does it wake you up in the middle of the night or affect
Yeah.
your sleep?
Yes, sometimes the pen wake me up,
Okay. How often does that happen?
but sometimes not. It's not every week. I feel it wake me up, but it bother me every day. But sometimes I can't tell you. Sometimes I wake up, I sit down for like 30 minutes, and after I lay down again.
Okay. And then you're able to go back to sleep?
No, I sleep. Maybe sometimes I sleep like 2 or 3 hours after when you wake me up.
Okay. What about in the morning? Does your back bother you at all then?
It bother me, but when I finish to drink, to take a hot shower, I feel better. Than
Okay. Now, you take Motrin for the pain?
yes,
How often do you take that?
sometimes I take Motrin 2 or 3 times a week.
Okay. Are there days that you take more than others?
The day,
Are there days where you take more Motrin than other days?
yes.
Okay. Now, let's talk about activities. Okay. Tell us how these injuries affect your physical activities.
My activity, but I, when I clean, sometimes I can mop.
Okay.
know?
What happens to you when you try to clean?
Yeah, when I try to clean, my I bloom. I don't have any problem with bloom, but when I mop, it bother me in my back.
Okay. So you have no problems when you use the broom, but when you mop, it bothers your back? Is that every time you try to mop?
But now I don't mop because every time I try to, it bother me. I let my kids do that.
Your kids help you?
The kids.
Okay. Are there any other activities, physical activities that are interfered with because of your injuries?
Oh, when I go to the supermarket, I can carry heavy stuff.
Okay. Do you carry some bags?
No, I can carry heavy, like bread stuff, light like that. I carry, but like water, juice, no.
Okay. Is there a limit, a weight limit on how much you can carry when you go to the supermarket?
How much?
Yeah, yeah. Do you have an understanding of how much weight you can carry
Oh,
and how
but
much weight you can't carry?
I just carry the light thing because I don't carry the heavy thing because I don't want bother me.
Now, before this accident, did you have any problems going to the supermarket?
No, I don't. Before, no, I don't have any problem.
Okay.
I don't have any accident before.
Okay. You never had a prior accident, right? Did you ever have a prior accident before?
No,
Okay. Now, are there any other activities that are interfered with because of your neck and back pain?
I can bend down. It's a little bit difficult to bend down.
What happens when you bend down?
I have to put my hand and my knee to bend down because my back, or I have to hold my back with one hand and with the other hand and bend.
Okay. Is that every time you try to bend down?
Yes.
Okay. And how long has that been happening to you?
How long?
Yeah.
I don't understand that question.
Okay. Has that been the case with you since the accident?
Yes.
Since did you ever have this problem before the accident?
Oh no.
Are there any other activities or physical activities that are interfered with because of your injuries?
Say it again, please.
Are there any other activities that you have difficulty doing because of your injuries?
Oh, but before I walk, um from home health aid. Now I can't do it because, you know, to working with heavy people like that, you have to, sometimes you carry the people to put transfer in the bed, to transfer in the chair. Now I can't do it. That's why I changed my job.
Okay. So you don't do your job anymore because of that?
No, I don't do it no more.
You don't work any longer as a home health aide?
No.
And that's because, could you explain a little bit more why you can't work as a home health aide anymore?
No, because my back hurting me. Sometimes they send you, they give you one case, you have to transfer people. I can't do it. Every time they send me somewhere, I can't do it. Now I quit.
Okay. When did you stop being a home health aide?
I start with my faith December 2017.
Okay. Now, you work in a different job now, right?
Yes. But I do light job now. I can do heavy job.
Okay. Is there any other activities that you have difficulty doing or can't do anymore because of your injuries?
No. I braid people hair only. I don't do nothing heavy. I don't carry nothing heavy.
Okay. You currently work in a different job, right?
Yes.
And is that, where is that job?
Where or what kind of job?
What
Where?
type of job is it? Yeah.
I just do people hair.
Okay. In a salon?
Yes.
And that job is lighter
Yes.
than the other job?
Yes.
Are there any other activities or limitations that you still have? Are there any other limitations that you have physically because of your injuries?
Uh-huh. I don't understand that question.
Okay. Do you have any other problems still with your neck or back that you haven't told us about already?
No.
Okay. And just to be clear, your left foot is fine.
It's fine.
Okay. I have no further questions, Your Honor.
Okay, Mr. Lavoy, do you have cross-examination questions?
Yes, Judge. Thank you.
Your Honor, if I may, can we just take a 2-minute break before he starts his cross-examination? I have to,
Yes. Yes,
Thank
we'll take 5 minutes, okay?
okay, thank you, Judge. Stay, Ms. Bonet, stay here. I have to go outside for a second.
All right.
During the break, you can turn your camera and microphone off if you wish, and we will come back at 10:55. Okay, I'm sorry, that went a little longer than we thought, but we had a couple of things to take care of. Mr. Fagundio, I think you're going to need to unmute your client again. I'm sorry.
Are you on the screen? Okay.
Yes.
Okay. As soon as Mr. Fagundio is back at his desk. Okay. Mr. Lavoy, you can proceed with cross-examination.
Thank you, Judge. Ms. Bonnet, at the time of this accident, you worked as a home health aide, correct?
Yes.
Can you just speak up? I'm not sure everybody could hear you.
I say yes.
Okay. And after the accident, you continued to work as a home health aide, correct?
Yes.
And you were working at Homewell at the time, right?
Well, yes.
Okay. Judge, can you, she sounds very faint to me. Can you hear her clearly?
I say yes.
Okay,
All right, just lean in a little bit or speak a little louder. I mean, I'm able to hear okay.
okay, she's just faint, that's all.
Okay.
Now, before Homewell, you worked as a home health aide for another company, A&T, right?
Yes.
And you did that for about 5 years?
Yes.
Okay. And before the accident, you were working the night shift, correct?
Before the accident? Yes.
And after the accident, you were working the night shift, right?
I used to work in the night shift before the accident.
And after the accident, correct?
Yes.
And then after Homewell, you switched jobs to do hair braiding at, I believe, Luna Salon, right?
Yes.
Okay. Now, isn't it true you left Homewell because your patient died?
The patient died? I don't understand that.
The reason that you left Homewell was because your patient died, right?
No.
No?
He wasn't died before I leave.
He didn't die before you leave?
No.
Okay. Do you remember around June 2019 that you took a deposition? I believe it was probably at your attorney's office, and you answered a bunch of questions with another attorney. Do you remember that?
Yes, I remember.
Okay. And do you remember as part of that deposition, there was a court reporter there and she was recording what everybody said that day?
Yes.
Okay. And the court reporter, before the deposition started, swore you in to tell the truth. Do you remember that?
Yes.
And I'm assuming you told the truth that day, right?
Yes.
Okay. Now, I don't know if you have it in front of you, but if not, maybe your attorney can provide it, your deposition transcript. Judge, I'm going to refer to the deposition transcript.
Ms. Bonnet, do you have the deposition transcript there with you?
Deposition. What is that?
I'll come over. I'll come over.
And Judge, I don't know if you want to explain to the
I have
jury.
nothing in front of me, only the computer.
Okay. While he's doing that, ladies and gentlemen, before a case gets to trial, a complaint is filed with the court, and during the course of litigation until the case goes to trial, there's a period called pretrial discovery. During the pretrial discovery period, the parties exchange information. Part of that exchange is written answers to interrogatories that are signed and certified to be true. And also, oral deposition testimony can be taken. When a deposition is taken, it's taken in front of a court reporter who is authorized to administer an oath. An oath is given the same as if the witness was testifying in a court of law. And after the deposition is completed, the court reporter prepares a transcript of that proceeding. And that is what Mr. Lavoie is now referring to, the transcript of a deposition that was conducted in this case. You can proceed, Mr. Lavoie.
Thank you, Judge. Ms. Bonnet, do you have the transcript in front of you?
Yes.
Okay, I'm going to ask you to turn to page 21. Tell me when you're there.
Yeah, but I don't read English good.
I'm sorry?
Yes, I don't read English good.
I'm not sure I really understood that.
She doesn't read English
Okay.
Very well. So perhaps when you direct her to the page and line number, you can read along with her.
That's what I'll do. Exactly.
Okay.
Just tell me when you're at page 21.
Yes.
Okay. And you see on the left-hand side of the page, there's a bunch of numbers next to each line that starts at 1 and goes to 25.
Yes.
Okay. I want you to go to line 23.
23, yes.
You see that?
Uh-huh.
Okay. I'm going to read to you and you follow along with me. The question was, why did you leave Homewell? The answer, because my patient died. I don't want to do it for them no more. Okay. That's what you said during your deposition. Right?
My patient, he wasn't died before that. I leave after a few weeks, he died. but I can't do that job no more.
Well, that's what you said during your deposition, isn't it true? Right?
Yes, I said that. But
And you
it
were,
was after 3 days I left, but I can't do that job no more because I feel pain. I can't do that job. They call me, they give me another case. I can't do it. I leave that job.
well, Ms. Bonnet, you were telling the truth during this deposition, correct?
Because
No, just listen to my question.
yeah,
You were telling the truth during the deposition, correct?
it was after that. It was that after that. But sometimes when they ask me the question, I don't speak English well.
Oh, Ms. Bonnet,
That's what.
Miss
Yes.
Bonnet,
Yes.
you at the beginning of the deposition, and I can go through it with you if you like me to. You had ample opportunity to use an interpreter, but you chose not to. Isn't that correct?
Can you say it again, please?
At the beginning of the deposition, when you were there, there was a lot of discussion about whether you could understand English, just like today. You're not using an interpreter, and you chose not to use an interpreter at the time of the deposition, right?
Speak quicker.
Do you understand what I'm saying?
Can you speak slowly because you speak fast? I can.
Okay.
Mhm.
I'm talking. Remember the deposition when you were there?
In the office or in my job?
No. I'm talking about at your attorney's office where you are now. There was a court reporter,
Okay.
and there was another attorney who was asking you questions.
Uh-huh.
That's what I'm talking about right now.
You have to answer yes or no.
Okay.
Okay.
So yes, you remember that?
Yes.
Okay.
Okay. Now, at the beginning, before they started that deposition, there was a lot of discussion about whether you could understand English well enough and wanted an interpreter. And you said you understand English well enough. Isn't that right?
I understand English, but not all, but I understand. I understand what you say right now.
Are you understanding what I'm saying right now?
Yes, I understand.
Okay. And you understood what the questions were during that deposition, right?
Doing that position?
Yeah, when they asked you the questions, you understood what was going on then, correct?
Yes.
Okay. And you told the truth, right?
Yes, but the patient died after a few weeks. I leave the job because I can't do it.
Well, okay. Again, look at page 21, line 23 of the deposition. I'll read it to you again. That's not what you said.
I said.
The question was, why did you leave Homewell? And your answer was, because my patient died. I don't want to do it for them no more. Right. And like we said before, you were telling the truth then, right?
Yeah, he was died, but he died after a few weeks. I leave the job.
Okay.
And I don't want to do that job no more because it's hard for me.
Oh, but you didn't say that during the deposition.
Maybe the lady not understand what I tell her.
Well, you didn't say you didn't understand the question, right? Right? You didn't say that at the time. You didn't understand. Right?
So maybe sometimes the question when you ask people question, it look like another question. That's why I tell her he died. I don't want to do that job no more. But I don't leave that job that because the patient died, because I leave before he died.
Okay, Ms. Burnett, let's try it this way. Turn to page 9 of that deposition transcript, if you could. Tell me when you're there.
Yes.
Okay, you're on page 9. Go to line 11. And I'll read it. I'll read with me. The question was, do you feel like you'll be able to answer in English? The answer, yes. The question, to all the questions, the answer, yeah. But if I don't understand, I'll tell you I don't understand.
Yeah.
Right? That's what was discussed at the beginning of that deposition.
Yes.
And when we asked you, the attorney asked you why you left Homewell, you didn't say you didn't understand, right? You answered the question.
What question? What number is that?
Going back, to what we were just talking about on page 21, right? You didn't say at the time when they asked you why you left Homewell, you didn't say you didn't understand that question, did you?
Yes, I say I understand, but sometimes the question they look like the same question, but it's not. But you see, the way you speak English, I don't speak English like that. You know, that's
Right, but
right.
you understand what I'm saying now, don't you?
What did you say?
You understand me now, don't you?
Yeah, I understand what you say. If I
Okay, and you understand English pretty good, right?
not pretty good because I don't go to school for English.
No, but you understand when people are talking, everything in this trial so far, you understand, right?
I don't understand all, but I understand most of them.
When your attorney was asking you questions, did you understand him?
When people ask me questions, but slowly I take my time, I understand. But
okay. Let's move on. Getting back to the accident, right? After the accident, you moved your car to the side of the road and waited for the police to come, right?
No, when my car now when the police come, she tell me to move it to go it's closed. Where I moved the car, it was closed.
Right, but before the police got there, you also moved your car a little bit, right? To the side.
I don't remember.
You don't remember?
Yeah, when the police come in, she tell me.
So you don't remember if you moved your car after the accident?
It's been almost 5 years ago.
Okay, let's since you have your deposition transcript in front of you, let's go back to that. Turn to page 47.
I remember. I don't remember because it's too much. Page
47. And then line 9. Tell me when you're there. Are you there?
Give me 1 second. Yes.
Okay, follow along with me as I read. Line 9 now. The question was, so at the scene of the accident, after the man came over and said he was going to call the police, you just pulled your car over to the side of the road. Answer, yes. And I sit down in the car.
Yes, I sit down in the car. Yes.
All right. So that was my question. You moved your car
after
the accident, correct?
Yes.
Okay. And you were released from the emergency room the same day, right?
Yes.
Right. Now, after this accident, you took a trip to Haiti, right?
To Haiti in December, not after the accident.
Well, the accident was in June. December's after June, right?
Yes.
And so you took a trip after the accident.
Yes.
Right. And you flew to Haiti, correct?
You flew?
Plane.
Yes.
And then you visited your family while you were there?
Yes.
And then you flew back home, right?
Yes.
Okay. And you didn't repair your car after this accident, correct?
My car, no.
Right. You only got some scratches on the rear bumper, right?
Yes.
Okay. And I'm going to share my screen with you to show you a couple of pictures. You've seen these before. Let me see here. All right. Can you see that? Miss Bennett, can you see that picture? Miss Bennett? Can you hear me? Judge, can you hear me?
I can hear you. Miss Bennett, are you able to hear?
I'll go over. Can you hear?
Yes.
Okay.
All right. So, Mr. Fagundio, can you hear me?
Breaking up.
No, I don't.
Judge, can you hear me now?
Breaking up.
It's breaking up.
No. Can you hear me now, Judge?
It's a little garbled.
Ms. Burnett, can you hear me?
Her, she can't hear because it's like scratchy. You can't hear anything. So maybe we could log her back in, I guess, or.
Sure. Let's take a break. We'll take a 10-minute break. We'll come back at around 11:30 or so, and by then we'll hopefully have that straightened out.
You were going so well.
You can turn off your cameras and microphones, and we'll be back in 10 minutes. All right, we're back. We're back on the record in the matter of Burnett versus Stubbe, docket number L 1843-18. And so you can continue, Mr. Lavoie, with your cross-examination of the plaintiff.
Thank you, Judge. Okay, before we had that technical difficulty, and we were doing so well before that, I was going to share my screen. So let me try to do that again. Ms. Burnett, can you see that picture on your computer?
Yes.
Okay. And this is, I believe, D2 for identification. This is a picture of your car, correct?
Yes.
And this is obviously a close-up of the rear of your car. And this is what it looked like after the accident, correct?
Yes.
Okay. I'm going to show you another picture now. This is D3 for identification. I'll represent to you, this is just another angle of the rear of your car after the accident, right?
After the accident, yes.
Okay. And that's what the damage was from the accident, correct?
But I don't know because I never hit my car in the back before.
Well, I mean, after this accident, when you looked at your car, eventually this is what it looked like, right?
Yes.
Okay. Judge, that's all the questions I have. Thank you.
Okay. All right, so Mr. Fagundio, do you have any further witnesses? I think you don't. So,
I have no redirect either, Judge.
okay. So you'll be resting at this point. By stipulation, exhibits P1 through P7 are in evidence. And are you ready, Mr. Lavoie, to call your first witness?
Yes, Judge.
All right, Mr. Lavoie, you can call your first witness.
I'd like to call Ryan Stubbe. Ryan, you can hear me okay?
I can. Can you hear me?
I can.
Perfect.
Okay.
All right, so I'm going to ask that you raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Stubbe, now that you're under oath, during your testimony, you must be alone in the room from where you provide your testimony. You must also turn off any other electronic devices except for the device that you are using to provide your testimony today. I will ask you, therefore, to certify these two things. Number one, are you currently and will you remain in the room by yourself during your testimony?
Yes.
Number two, is your cell phone and any other electronic device that you're not using for this presentation powered off, and will it remain powered off for the duration of your testimony?
Yes.
Okay, you can proceed, Mr. Lavoie.
Thank you, Your Honor. Ryan, just tell the jury where you live now.
Now I live in Boston, Massachusetts.
Okay. And I mean, what do you do for a living? Do you work?
Yeah, I work in financial services.
Okay. Now, around June 9th, 2016, where were you living?
Old Tappan, New Jersey.
Okay. And do you recall being in a car accident around that date?
Yes, I do.
Okay. And where were you driving when the accident happened?
I was headed from my house to the train station in Westwood, New Jersey to catch the train to work.
Was anybody in the car with you?
No, I was by myself.
And what vehicle were you driving?
It was a 2015 Volkswagen Jetta.
Okay. Where were you going? Well, you already said that you're going to work. Do you remember how the accident happened?
Yeah, so as we approached the intersection, the light changed from green to yellow to red eventually. And I thought the other car was gonna go through the, we were like right on top of the intersection when that happened. And I thought the other car was gonna go through the light. So I was going through the light too. And as was mentioned, the intersection was under construction, so the other car actually went past the white line where you normally would have to stop for a red light. So I took that as that they were going, which is why I went.
Okay. And how many impacts was it?
Just one.
And if I asked you to describe the impact, what would you say?
A tap, a light tap.
After the accident, did you observe if there was any damage to the vehicles?
Yeah, so I was actually the one who took the photographs. There was, some mild scratching to the paintwork of the other car. And my car had a crack in the license plate bracket. But that was it. There was nothing. And actually one small scuff that I actually took out with my thumb at the scene, but there was no other damage.
Okay. I'm going to do what I just did for Ms. Bonnet and share my screen with you. Can you see that?
I can, yep.
Okay. And I'm showing you what's been marked as D2 for identification. What's this a picture of?
This is Miss Bonnet's car, the bumper.
And did you say you took these pictures?
I did, yes.
Okay. And you took these pictures after the accident?
Right.
Okay. And this picture fairly and accurately shows what the damage to Miss Bonnet's vehicle was after the accident?
Yes.
Okay. I'm showing you what's been marked D3 for identification. What's this a picture of?
It's a different angle. Same thing though, the rear bumper. You can actually see the outline of the license plate bracket from my car.
And you took this picture also?
I did, yes.
Okay. I'm going to show you what's been marked D4 for identification. What's this a picture of?
This is the front of my car.
Okay. And is this what a fair and accurate representation of what the front of your car looked like after the accident?
Yes.
And this is D5 for identification. What's this a picture of?
The front of my car as well.
Okay, just a different angle, I guess.
A wider angle, yeah.
You could see the
front of the car, yep.
Right. And that's what your car looked like after the accident.
Correct.
Okay. Did the other driver, Ms. Bennett, appear injured at the scene?
Not injured, no.
Okay. And were you injured in this accident?
No.
No further questions, Judge.
Cross-examination, Mr. Fagundio?
Yes, Judge, I'm going to probably use Mr. Stubbe's answers to interrogatories. So two things. Please instruct the jury what answers to interrogatories are. And also if Mr. Stubbe could open up his file, which the file that the court gave us, so he can read along.
So members of the jury, as I indicated before, during the discovery phase, there are two things that can happen, among others. Written answers to interrogatories that are certified to be true under oath, and also the deposition. You've already seen the example of the deposition. This is going to be the example of the written interrogatory answers that are certified answers to be true.
Mr. Stubbe, do you have that file available?
Yes, I do. I believe it's the same file we're talking about.
Now, you've characterized the impact between your car and Miss Bonnet's car as a light tap.
Yes.
A light tap like this, something very minor.
Yes, I would characterize it as minor.
But it was strong enough for you to cause damage to the rear of her car, correct?
Yes.
Okay, and as a result of that damage, you had some damage to your car as well, correct?
Correct.
And if you look at the picture of your car, it looks like your front bumper is pushed in slightly on, if you're looking at the picture on the right-hand side, correct?
I would need to see the picture again.
Okay, so you don't remember that though, right?
No, and the bumper was not replaced. The paintwork on the bumper wasn't even damaged at all. You couldn't even tell.
Now, when your vehicle struck Miss Bonet's car, she was stopped, right?
Yes,
She was at a complete stop, correct?
she was. Yep.
How fast were you going when you tapped her?
Maybe 5 miles an hour, maybe
Okay,
less.
maybe less.
Yeah.
Now, I'm going to refer you to your answers to interrogatories, okay?
Mhm.
And I want you to go back down. It's in Form C1. It's really
Yep.
the last question. It's number 20. Okay. And those answers to interrogatories, you certified that those answers were true, correct?
Correct.
And you signed the signature page, which is basically the last page, and it says there's a signature there that says R. Stubbe. That's your signature, correct?
Yep, that's right.
Okay. And your answer to, I'm sorry, number 19. At the time of the impact, state the speeds of all vehicles involved in the collision. And your answer was, I was traveling at approximately 5 to 10 miles per hour, and the other vehicle was stopped. Is that accurate?
Yes,
So it was not less than 5 miles per hour. It was really
around 5 miles an hour.
approximately 5 to 10 miles per hour, because that was your answer here in your answers to interrogatories, correct?
Right.
Right. Okay. And as a result of the impact, Miss Bonet's vehicle moved forward approximately 1 to 2 feet after the impact.
Correct.
And she was at a complete stop when you hit her from behind, correct?
Yes.
And her vehicle went forward 1 to 2 feet as a result of your impact, correct?
Correct.
Would you still characterize that as a light tap?
I would, yes.
Okay. I have no further questions, Your Honor.
Any redirect, Mr.
No, Judge.
Mr. Lavoy, you don't have any other witnesses, I take it, correct?
Correct, Judge.
Okay. And so at this point, we can already stipulated into evidence were the D exhibits. That was, can you run through the numbers? It's D2.
Judge, I believe it's 2 through 5. I have to pull up the folder just to see it, and not 6, and then everything else. So everything except 1 and 6, I believe.
Right. Okay. Yes. So it's 2, 3, 4, 5, and everything above that. Okay. Those are in evidence. They were stipulated into evidence, so there's no issue there. Do you want to take our lunch break now and then do?
I just wanted to make sure my record, they're in evidence as well, right, Judge?
Yes, yes. When you rested, we just acknowledged for the record that I think it's P1 through 7
Correct.
are in evidence. So maybe that's a good idea. We can break for lunch now and come back at, say, 1:45.
That's fine with me, Judge. Did you want to?
Actually, why don't we do 1:15? So what we're going to do, ladies and gentlemen, is this. You're going to be able to go to lunch. My suggestion is that you don't disconnect from the meeting, but certainly if you wanted to, you can. But if you turn the camera and microphone off, you can just leave it. And we're also going to now move the documents that are in evidence into that jury folder that you have access to. You can take an opportunity to just start looking through those documents. The attorneys in this case have asked that you be permitted to do that so that you have some level of familiarity with what those documents are before they give their closing arguments to you in a little while. So you'll have an opportunity to do that. That's why I'm going to give you some extra time for lunch. So if you go now and we come back at 1:15, you'll have an hour and a half to have lunch and to also look through that folder, look at those documents and be familiar with them. You certainly don't have to examine them. I do not want you to begin your deliberations in any way, shape, or form. I want you to just enjoy your lunch and become familiar, and we'll see you back here at 1:15. Do the attorneys need to be seen at sidebar?
No, Judge, not for me.
All right, so we will see you back here at 1:15. Okay, everyone, we are back. I'm sorry for the delay. We just had a couple of minor issues that we needed to deal with, and we will have to deal with one other issue before we are ready to do the closing arguments, which is the next phase of this trial. And to do that, I think that we should probably go into the sidebar and address that issue. So I'm going to ask that the attorneys and juror number 5 be moved into the sidebar for a conference. Just so that everybody is aware, juror number 5 has been excused, and we can now move on to the next phase of the trial, which is our closing arguments. And the closing arguments go in the reverse order than the openings, so the defense has an opportunity to go first. So, Mr. Lavoie, are you ready for your closing argument?
I am, Judge.
Okay, you can proceed.
Thank you so much. Before I really get started, I would just like to take this opportunity again to say thank you all for not only serving as jurors, but doing so in this little odd format, virtual, that we're doing. Again, we really all together are making history. So there's something to be said for that. I never thought that I would say I would be making history in my life, but I guess here we all are. So thank you again for serving and taking the time. Now I'm going to try to share my screen because I have a presentation that I'd like to do for you guys. So just bear with me 1 second here. Okay, hopefully everybody can see that. You should be seeing a PowerPoint slide that says the plaintiff has the burden of proof on the top, and you can hear me clearly. That's what this case, as I said in the beginning, is about, ladies and gentlemen. The plaintiff has the burden of proof. Now, the plaintiff has to prove by a preponderance of the credible objective medical evidence that she sustained a permanent injury caused by this accident that happened back in June 9th, 2016. And a permanent injury, and this will be defined for you again by the judge when he gives the jury charge at the end. A permanent injury is one that has not healed to function normally and will not heal to function normally with further medical treatment. That is the definition, and that is what the plaintiff has to prove. Now, the permanent injury, again, has to be causally related to this accident. It's called proximate cause, and that's just another fancy legal term that the judge will define for you. But basically, it means that it can't be something that was pre-existing or from another cause. It has to be caused directly from this accident and proven by a preponderance of the credible objective medical evidence, which again is something like an MRI exam is an example of an objective test versus subjective complaints of pain. Now, you've seen this before, you'll see them again. You have them as part of your materials. This is a low speed accident. This is your really general fender bender type of accident that happens all the time. And the damage or lack thereof of the vehicles, I think, speaks for themselves. Okay. So what do we know though? And what have we learned so far? We know that the plaintiff was released from the emergency room the same day. Right? She wasn't admitted to the hospital. We know that she traveled to Haiti after the accident to visit her family. We know that she had conservative treatment. There was no surgery, no invasive treatment of any kind. She had a few months of chiropractic treatment, and that's it. Now, she claimed that she had complaints of her neck directly after the accident. If you recall her testimony, she said she went to the emergency room and she had complaints of her neck and back. But if you look at the records, ladies and gentlemen, if you go back when you deliberate and you look at the emergency room records closely, you'll see that, in fact, the plaintiff denied she had any head or neck pain. So then how credible is she really? What else do we know, though? We know that she continued working as a home health aide. And then she started doing work at doing hair at a salon, right? We know from her description of, she gave a little bit of a description of what she does as a home health aide and doing hair. These are not office jobs, right? These are not desk jobs. She left her job because her patient died. And you might recall, I went through the deposition transcript that she previously took under oath and was recorded by a court reporter. And she was asked very clearly why she left her job as a home health aide. And she said because her patient died, not because she couldn't do the job anymore, which she testified to today. So that's a direct contradiction to her testimony. So again, how credible is she? This is for you to decide. And what else do we know? We know that she could stand for hours with no pain. She said that she could stand for 3 to 4 hours before she feels pain. Well, I ask you, I don't know many people who could stand more than 4 hours before and not feel any pain or discomfort in their back, right? I mean, after standing that long, I would say most people would have some discomfort in their back. But most importantly, what else we know is that she hasn't treated at all since December 2016, right? That's more than 4 years ago. Nothing. Now, what else do we know? You heard from my client, Ryan Stubbe. And again, this trial was not about who caused the accident, but he decided to come today and give you his testimony as to the nature of the accident. And I hope you feel that he was credible. He explained exactly what happened, and he wanted to show up today to tell you his side of the story. So you could hear it, directly from him. Let's talk about some of the medical records that you're going to have already hopefully taken a look at and that you'll look at a little bit more closely when you deliberate. Now, the plaintiff's treating doctor in this case was a chiropractor, Dr. Evans, right? Now, he's a chiropractor. He's not a medical doctor. Okay, there's a difference. He hasn't seen the plaintiff since December 10th, 2016. That's the last time. That's the last treatment. If you look in the treatment notes, which you should have, which is different than there's a narrative report that summarizes pretty much everything by Dr. Evans. And then there's individual treatment notes with the individual dates that she came. The last treatment date was December 10th, 2016. Okay. Here is the note. So when you go back and you deliberate, this is what it looks like. And there you can see December 10th, 2016. Now, at the end of that visit, he said the patient should return next week. But we know that didn't happen. That was the last time she ever went back. So she decided not to get any treatment after that date. What else do we know about Dr. Evans? He first saw the plaintiff 11 days after the accident. Not the next day, not 2 days later, not 3 days later. 11 days was the first time that she saw him. Now, he diagnosed the plaintiff with post-concussive headaches. This is in his narrative report. Okay. And the only reason I'm pointing this out to you is, again, it goes to credibility. You have heard nothing in any testimony today about post-concussive headaches, have you? if you look through all the medical records that you have, other than that line in his narrative report under diagnosis, there's nothing about post-concussive headaches. Now, why is that? Because that has nothing to do with this case, okay? She never once complained about having a concussion or complained about having any headaches. My point is, this was probably an error that was put into this report. Why? I don't know why, but my guess is that Dr. Evans writes these reports rather frequently, and maybe he forgot to take this out from a prior report. I don't know. All I know is that this has nothing to do with this case, but yet it's in that report. So if this is in the report and we know it's not relevant to this case, what else is in this report that perhaps is a little suspect? Now, he mentions the MRIs, right? Now you have the MRI reports, and he also mentions the MRIs. If you just compare them, frankly, we don't know if he ever did any independent review of the MRI films. He doesn't say anything. All he does is parrot the exact diagnosis that the radiologist said, and repeats what the MRI reports say, right? There's no independent analysis. I don't even know if he's qualified to review MRIs, but all he does is repeat what the radiologist says. So what can we glean from that? I don't think we can glean anything. We don't even know if he reviewed the emergency room records, because there's nothing mentioned in his report about any documents that he reviewed. You would think if somebody went to the emergency room and you're a treating doctor, that might be something you might want to look at, right? But there's not, as far as we know, he didn't, because it's not in his report. And you would assume if he did, he would have put that in his report. Like Dr. Dreyer, he gives you a list of all the documents that he reviewed in preparation for his final analysis. Now, make no mistake about it, ladies and gentlemen, what the plaintiff wants you to believe is that her whole spine is broken up. The cervical is the upper part with the neck, the lumbar is the lower part of the spine, and the thoracic is the middle. I think I had that right. But according to the MRI reports, her whole spine has bulges in it, right? And the plaintiff wants you to believe all of those bulges, her whole spine, was caused by this accident. Does that make sense to you? That's for you to decide. But that's what she's saying. Now, bulges, which is what the MRI indicate, if you look in the glossary of terms, which you have, take a look. It defines disc bulge for you. And I'm not going to repeat what this whole thing says, but basically what I want you to understand is that a bulging disc is a normal phenomenon that usually occurs as the body ages. It's part of the degeneration process, part of degeneration disc disease, which I mentioned in my opening remarks, and which Dr. Dreyer notes as what is going on in the plaintiff's spine. That's what a bulge is. It's not caused by trauma from a car accident, and especially not this car accident. So the plaintiff also saw a Dr. Cola, but she only saw him 2 times. He didn't do anything for her. The last visit was in October 2016, and she told him she had no neck complaints, right? Which is more consistent with what the emergency room records say and the other records say. Only the plaintiff told you that she had neck complaints, but that's really not, other than Dr. Evans, that's not summarized anywhere else. Okay, so he didn't give her any type of treatment whatsoever. Now let's compare Dr. Evans and Dr. Kohler to Dr. Dreyer. Dr. Dreyer and his CV should be part of your materials. He's a board certified orthopedic surgeon, okay? The plaintiff, not one time after this accident up until today, saw an orthopedic doctor ever, not even once. You would think if somebody has neck and back complaints, they would go to an orthopedist, right? That's what they do. So Dr. Dreyer is an orthopedic surgeon. He's board certified. He's a medical doctor. Now, he reviewed the MRI films, and he did an independent analysis, and you will see that in his reports. I believe it's the second and third reports, if you put them in chronological order. But he tells you what he found, and there's no doubt that he reviewed the films because he says he did, right? And he was the last doctor to examine the plaintiff, and that was in November 2018. So that's more than 2 years after this accident, more more than 2 years after Dr. Evans ever saw the plaintiff, Dr. Dreyer had the opportunity to examine her. And so he is the person who most recently saw her. And he determined that she had a normal physical exam. And you could read that. I'm not going to bore you by going through it paragraph by paragraph. That's the benefit of you having the reports. You can read it for yourself. These are just some of the highlights I want to point out for you. Now, Dr. Dreyer found when she went to him that she complained of intermittent back pain, right? Meaning it's not constant. So does that sound like a permanent injury? Something that's not constant? He found her to have a normal physical exam. She didn't have any complaints of her neck at that time, which is, again, consistent with the other records. No pain or range of motion issues. Now, the left foot was normal, but again, the left foot in this case is really a non-issue because she said her left foot is fine now, and she never had any treatment about it. But he did look at it because it was part of her original complaints. Now, Dr. Dreyer, he did review the ER records, okay? And again, the ER records clearly said that she didn't have any neck complaints or head complaints at the time. He reviewed the x-rays that were taken at the emergency room. And the x-rays, if you look at them, they show degenerative spondylosis in the back. Again, use the glossary of terms to help you define that, but the word degenerative says it all. It's a natural condition. Now, again, Dr. Dreyer reviewed the MRIs, and when he reviewed the neck MRI, what did he find? He found evidence of degenerative disc disease. And as we all know from the definition, that's a normal age-related condition. Unfortunately, it's something that happens to pretty much everybody as we get older in different severities. Everybody's different, but there's really no way to escape it unless you're Superman. This is going to happen at some point. So use the glossary of terms again if you want to refresh your recollection as to what the medical definition of that is. There's no evidence here of any trauma at all from this accident. He notes the bulges, right? Nobody's saying that these bulges don't exist, but what we're saying is that these bulges were not caused by this accident. They were routinely observed in MRIs of people of this age. And other than that, this was a normal MRI for somebody of the plaintiff's age. That's what Dr. Dreyer is saying. He also reviewed the back MRI and he found the same thing, degenerative disc disease, which is consistent, right? If she has bulges throughout her entire spine, what makes more sense? That they were traumatically caused by this car accident or that they're a symptom of a natural condition that's affecting her entire spine? Again, no evidence of any trauma here. This was an otherwise normal MRI for a person of the plaintiff's age. So degenerative disease, this is what you will find in the glossary of terms. It's basically normal changes to a person's spine as the person ages, okay? It can occur anywhere in the spine. And again, it's something that happens to pretty much everybody. Now, keep in mind, complaints of pain, which really is all this case is about, is her subjective complaints of pain. That doesn't meet her burden here. That's not what the burden of proof is required by the law, right? Again, you need objective, credible medical evidence. Now, which expert do you find more credible? A radiologist who all they do is interpret the film. So if there are bulges, he will say there are bulges, and that's what he did here. A chiropractor who's not a medical doctor or an orthopedic surgeon, or a board certified orthopedic surgeon. Which is more credible to you? So when we're talking about whether this is a permanent injury and whether the plaintiff has met her burden of proof, does this all add up to you? She was released from the emergency room the same day. She took a vacation to Haiti after the accident. She returned to the same job and worked another 1.5 years as a home health aide, right? She was a home health aide at the time. After a couple of days, she came back to work as a home health aide, and she did not stop. She testified until December 2017. And the accident was June 9th, 2016. And when she stopped, again, I went through this with her deposition transcript, and I try not to belabor the point. but she very clearly testified in her deposition that the reason she stopped was because her patient died. And that makes sense. Your patient dies, you need another job. Not because of the injuries from this accident, okay? She said today, her neck bothers her a little in the morning, but it doesn't interfere with any activities, any daily activities. That's what she said today. Because I wrote it down when she said it. And does that sound like a permanent injury to you? Now, we know the plaintiff hasn't treated since 2016. We know she has no plans for any future treatment because there's nothing to indicate that she does. She didn't say that. There's nothing in the records to indicate any need for any future treatment. There's no recommendation for any surgery by any doctors. We know she didn't see an orthopedic doctor at all. And there's no recommendations by anybody for any future treatment. So again, does this sound like a permanent injury? Ladies and gentlemen, the plaintiff does not meet the burden of proof in this case. And again, permanent injury is one that has not healed to function normally and will not heal to function normally with further medical treatment. And we know that she hasn't sought any further medical treatment in over 4 years now. So again, you've all heard the phrase, I'm guessing that you've heard, a picture speaks 1,000 words, right? It's a pretty common phrase. Nothing fits that better than this case. The pictures speak for themselves, okay? Now, I don't know what the plaintiff's attorney is going to say to you, but one may guess that he's going to try to say that, you know, the impact from the accident was 10 miles an hour, and, you know, just because you don't see the damage doesn't mean it wasn't a big impact. I don't know. I'm only guessing. But nobody knows what the speed was, but the pictures speak for themselves, right? If it was a larger impact, you would have seen more damage. There's absolutely, I don't even see a scratch on Mr. Stubbe's car, okay? So at the end of the day, all the evidence leads to only one conclusion here, that there was no permanent injury caused by this accident, and that the plaintiff failed to meet her burden of proof in every way, that the injury is permanent, that the injury was caused by this accident, and that it was proven by the objective, credible medical evidence. So again, let me stop my screen here. So can you see me? Am I back?
Yes.
Okay. So that's the story, ladies and gentlemen. And again, thank you for your time. And I hope that when you go back to deliberate and you review the records one more time, you use your common sense and you figure out exactly what this case is and what this case is not, and you return a verdict in the defense's favor that the plaintiff has not sustained a permanent injury caused by this accident. Thank you so much.
Thank you, Mr. Lavoy. Mr. Fagundio?
Thank you, Judge. May it please the court. Let me just make sure I'm okay. I must first begin by saying that this was not a light tap on the rear of Miss Bonet's car. The defendant, by his own admission, stated that he was traveling approximately 5 to 10 miles per hour when he struck Miss Bonet's car when she was completely stopped. As a result of the impact, she moved forward approximately 1 to 2 feet. I believe she stated it was a little bit farther. It was strong enough for her to have her glasses knocked off her head into the car. Now, I'm going to go over some of the records that you will have in evidence in this case. And the records that I've submitted are in your evidence folder, and they're numbered P1 through P7, and they'll be at the bottom of the folder. P1 is the police report. And I ask that you look at the police report. And on that police report, you will see it's a one-page report. At the top of the report, the police officer put in total injured. He indicated one person. That would be Miss Bonet. And then at the bottom of the report, you'll see Miss Bonet listed as an occupant of the vehicle, and directly to the left of her name is a number, 5206, which is the ambulance run number that took her. That's the number of the ambulance. Well, that's the hospital code for the ambulance, so that they can track where she's going to be delivered at which hospital. And that code is for Hackensack Hospital. So then, if you look at Exhibit P2, that is the emergency room record. And the record's not that long, but if you go through the record, and I believe it's a couple pages in, well, the first page shows that she arrived by ambulance. The second, the third, the fourth page shows clinical statement, motor vehicle crash and neck pain. So obviously there was a complaint of neck pain in the emergency room, contrary to what my adversary just stated to you. So if you look at the emergency room record, that is in there. And if you go further through the record, you'll see that the x-rays were performed of the left foot and of the lower back as well. There's a description of her symptoms and her complaints of pain. Thereafter, if you look at exhibit number 3 is Dr. Evans' report. And Dr. Evans, in his narrative report, describes his objective findings. He describes his physical findings of her. He describes what her complaints were. And he states later on in his report that he believes that she has sustained a permanent injury. Furthermore, if you go to my exhibit P number 4, that's a certification of permanency. And the law in New Jersey requires that the treating physician sign an affidavit, a certification stating that it is his opinion that his patient suffered a permanent injury as a result of the accident. Now, I bring that up because Dr. Evans is the treating physician in this case. He treated her for 6 months. He sent her for neurological testing. He also sent her for the MRI studies. The defense doctor in this matter is a consulting expert. He was retained by the defense to look at records and render an opinion for court. Why do I focus on his opinion, or the word opinion? And the reason why I focus on that is because Dr. Dreyer's report, the defense doctor in this case, it is his opinion that the plaintiff did not sustain a permanent injury. But it's merely an opinion. And you have to understand that he only saw the plaintiff one time, and he looked at multiple copies of records. But the plaintiff's doctor treated her for 6 months and saw her regularly during that 6-month period of time, sent her for diagnostic testing, sent her to a neurologist, and he developed his own opinion based upon his view and treatment of the plaintiff and review of the diagnostic studies. But I have to point out that the defense doctor in this matter, it's still just an opinion. It's not fact, okay? An opinion can be held differently by many different people, but his opinion is not gospel and it is not a fact. It's merely an opinion. Just want you to remember that. Next, I want you to look at Dr. P number 5, which are Dr. Evans' treating notes. And in those treating notes, Dr. Evans documented what Ms. Bonnett's complaints were. And they're documented for every single visit. And every single complaint that she had and what he did for her is documented in those records. And you can read through them all. The relative, I mean, it's a lot of paper, but the records start in June and they end in December 2016. And if you pick out any single one of those dates of treatment, her complaints and his findings are documented there, and you can look at that. Next, P number 6 are Dr. Cola's records. Dr. Cola is a neurologist, and he saw Miss Bonnett 2 times after the accident, and he had his findings in there. In addition, P number 7 is the MRI study, and the radiologist performed the study, MRI study of Miss Bonnett's neck and back, and he wrote his findings there. Now, Miss Barnett did not have any prior accidents. She did not have any pain prior to this accident. All of her symptoms and her complaints were as a result of this accident. I would just respectfully request and ask that you review all the records, and at the conclusion of your review and consideration, that you render a fair and reasonable award for Miss Barnett. That's all we ask for. Thank you.
Thank you, Mr. Fagundio. Do any of the jurors wish to take a break before we begin the jury instructions? Just raise your hand and let me know if you want to take a break. Otherwise, we can start right up. I have to warn you, though, that it's really the most boring part of this whole thing, and it's important that you are awake and alert for all of it. And since I'm not the most dynamic speaker, you'll just have to suffer through it as best you can. But I don't see any hands raised. Is there a hand raised anywhere? Okay, so we'll plow right through, and we'll go ahead with the jury charge. Okay. So now I'm going to tell you about the principles of law that govern this case. And you're required to accept my instruction as to the law. You should consider these instructions as a whole and don't pick out any particular instruction and place any undue emphasis on it. Any ideas you have of what the law is or what the law should be, any statements by the attorneys as to what the law may be, must be disregarded by you, and you must be guided solely by what I tell you. And if they are in conflict with what I tell you, then you, in that event, must abide by this charge. Sorry about that. I sit here as the judge of the law. As part of this responsibility, I've made various rulings and statements throughout the trial. Don't view these rulings as statements as clues about how I think the case should be decided, because they're not. They're based solely on my understanding of the law and the rules of evidence, and they don't reflect any opinions of mine about the merits of the case. Even if they did, you should disregard them, because it's your role to decide the case and it's not mine. The lawyers are here as advocates for their clients. In their opening statements and in their summations, they've given you their views of the evidence and their arguments in favor of their client's position. While you may consider their comments, nothing that the attorneys say is evidence, and their comments are not binding upon you. You sit here as judges of the facts. You alone have the responsibility of deciding the factual issues in this case, and it is your recollection and evaluation of the evidence that controls. If the attorneys or I say anything about the facts of this case that disagrees with your recollection of the evidence, it's your recollection you should rely on. Your decision in this case must be based solely on the evidence presented and on my instructions on the law that I'm giving you now. So the evidence in this case consists of the police report, the medical reports and records, and the glossary of terms that you have in your jury folder. You will access those, as you probably have already, but you'll access those and review them during your deliberations. In addition to those documents, the evidence is the testimony that you heard from the witness stand, the deposition testimony and interrogatory answers that were read into the record, the stipulations that were placed on the record, and it was stipulated that the defendant was the cause of the accident. You'll recall the stipulation and what was agreed to in that regard. So therefore, you can accept that as true as part of your deliberations. As I told you from the beginning, this case arises out of a car accident that occurred on June 9th, 2016 on Westwood Avenue in Rivervale, New Jersey. On that date, defendant Ryan Stubbe was driving a vehicle that struck the vehicle driven by the plaintiff, Louamine Bonnet. Plaintiff Louamine Bonnet alleges that as a result of the accident, she sustained permanent injuries to her neck and back. Defendant Ryan Stubbe admits that he caused the accident, but disputes the nature and extent of the plaintiff's injuries. Now, the plaintiff bears the burden of proof to establish her claim by a preponderance of the evidence. In other words, a person who makes an allegation must then prove the allegation. In this action, the plaintiff, Louamine Bonnet, has the burden of establishing by a preponderance of the evidence all of the facts necessary to prove that she sustained a permanent injury as a result of a permanent injury as defined in these instructions that I'm giving you. The party with the burden of proof has the burden of proving his or her claim by a preponderance of the evidence. If the party fails to carry that burden, the party is not entitled to your favorable decision on that claim. To sustain that burden, the evidence supporting the claim must weigh heavier and be more persuasive in your minds than the contrary evidence. It makes no difference if the heavier weight is small in amount, as long as the evidence supporting the claim weighs heavier in your minds, then the burden of proof has been satisfied, and the the party who has that burden is entitled to your favorable decision on that claim. However, if you find that the evidence is equal in weight, or the evidence weighs heavier in your minds against the party who has the burden, then the burden of proof has not been carried, and the party with the burden is not entitled to your decision on that claim. In this expedited jury trial, the attorneys have produced evidence in the form of live testimony and also in the form of written materials. As I said, the expert reports, the records, the police report. You will have to decide which evidence to believe and which evidence not to believe. Regardless of whether the evidence comes from a layperson or an expert, you may believe all of it, only part of it, or none of it. In deciding what evidence to believe, you can take a number of factors into consideration. One, the interest, if any, the witness or preparer of the written materials has in the outcome of the case. Two, the accuracy of the recollection of the witness or the preparer of the written materials. The ability of the witness or preparer of the witness material to know what he or she is talking about. The reasonableness of the evidence, the demeanor of live witnesses on the stand, the witness's candor or evasion, the witness's willingness or reluctance to answer a question, the inherent believability of the evidence, the presence of any inconsistent or contradictory statements. If you believe that any witness or party willfully or knowingly testified falsely to any facts that are significant to your decision in this case, with the intent to deceive you, you may give such weight to his or her testimony as you deem it's entitled. You may believe some of it, or you may, in your discretion, disregard all of it. Your oath as jurors requires you to decide this case fairly and impartially, without sympathy, passion, bias, or prejudice. You are to decide this case based solely upon the evidence that you find believable and in accordance with the rules of law that I am now giving you. Sympathy is an emotion which is normal for human beings. No one can be critical of you for feeling some degree of sympathy in this case. However, that sympathy must play no role in your thinking and in the decision you reach in the jury room. Similarly, your decision must not be based upon bias or prejudice, which you may have developed during this trial for or against either party. Your duty is to decide this case impartially, and a decision based on sympathy, passion, bias, or prejudice would violate that duty. The evidence in this expedited jury trial includes reports from experts. Generally, witnesses can only present the facts and are not permitted to give opinions. However, an exception to this rule exists in the case of an expert. An expert may give an opinion on a matter in which he or she has some special knowledge, education, skill, experience, or training. An expert may be able to assist you in understanding the evidence in this case or in performing your duties as a fact finder. But I do want to emphasize to you that the determination of the facts in this case rests solely with you as the jurors. In this case, the reports and records of the following experts were marked into evidence and contained certain opinions. Dr. Seyraman Chara Kola, I'll never say that name right, Dr. Robert Evans, Dr. Robert Taflet, Dr. Joseph W. Dreyer. In examining the opinions of each expert, you may consider the person's reasons for rendering the opinions, if any. You may also consider the qualifications of the individuals and the believability of the experts, including all of the considerations that generally apply when you are deciding whether or not to believe a live witness's testimony. The weight of the expert's opinion depends on the facts on which the expert bases his or her opinion. You, as jurors, must also decide whether the facts relied upon by the expert actually exist. Finally, as I've said before, you are not bound by the opinions of an expert. You may give them whatever weight you deem appropriate. You may accept or reject all or part of an expert's opinions. It is for you, the jury, to resolve any conflicts in the reports of the experts using the same guidelines in determining credibility that I mentioned earlier. As I stated before, the defendant has stipulated and agreed that he was the cause of the accident. The dispute in this case is whether the accident caused the injuries and the nature and extent of the plaintiff's injuries. In order to recover damages in this case, the plaintiff, Louamine Bonnet, must prove by a preponderance of the evidence that she sustained a permanent injury within a reasonable degree of medical probability other than scarring or disfigurement. If you find that none of the injuries caused by the accident are permanent injuries within a reasonable degree of medical probability, your verdict must be for the defendant. If you find that an injury caused by the accident is a permanent injury within a reasonable degree of medical probability, your verdict must be for the plaintiff, Louamine Bonnet. In this case, the plaintiff alleges that she suffered a permanent injury as a result of the motor vehicle accident. An injury shall be considered permanent when the body part or organ or both has not healed to function normally and will not heal to function normally with further medical treatment. The plaintiff must prove this claim through objective, credible medical evidence. Objective means the injury must be verified by physical examination or medical testing and cannot be based solely upon plaintiff Bonnet's subjective complaints. Credible evidence is evidence you find to be believable. If you determine that any one of the injuries contended by plaintiff Bonnet constitutes a permanent injury, then in that event, you should award damages to Louamine Bonnet in accordance with these instructions for all of her injuries that you determine to have been proximately caused by the negligence of the defendant, including those injuries that you find to be non-permanent. I'll also point out to you that a number of photographs of both vehicles involved in the accident have been introduced into evidence, and they've been shown to you. These photographs show the damage or depict the condition of the vehicles after the impact. As judges of the facts, you may attribute such weight to the photographs as you deem appropriate, taking into consideration all of the other evidence in this case. In some accidents resulting in extensive vehicle damages, the occupants may suffer minor injuries or no injuries at all. In other accidents where there is no or little apparent vehicle damage, the occupants may suffer serious injuries. In reaching your decision in this matter, you are to give the photographs whatever weight you deem appropriate. They are but one factor to be considered along with all of the other evidence in determining whether the plaintiff, Louamine Bonnet, sustained permanent injuries as a result of the accident. It is the duty of the plaintiff, Louamine Bonnet, to establish by a preponderance of the evidence that the negligence of defendant Ryan Stubbe was a proximate cause of the injury alleged to have resulted from Mr. Stubbe's negligence. The basic question for you to resolve is whether the plaintiff's injury is so connected with the negligent actions or inactions of Mr. Stubbe that you decide it's reasonable, in accordance with these instructions that I now give you, that Ryan Stubbe should be held wholly or partially responsible for the injury. By proximate cause, I refer to a cause that in the natural and continuous sequence produces the injury, and without which the resulting accident and injury would not have occurred. A person who is negligent is responsible for any injury that results in the ordinary events from his negligence. This means that you must find that the resulting injury to plaintiff Bonnet would not have occurred but for the negligent conduct of Ryan Stubbe. If you find that but for Ryan Stubbe's negligence, the injury would not have occurred, then you should find that Ryan Stubbe was a proximate cause of plaintiff Louamine Bonnet's injury. I'm now going to instruct you on the law governing damages in the event you decide the liability issue in favor of Louamine Bonnet. The fact that I instruct you on damages should not be considered as suggesting any view of mine about which party is entitled to prevail in this case. Instructions on damages are given for your guidance in the event you find that the plaintiff is entitled to a verdict in her favor. I'm required to provide instructions on damages in all cases in which the trial includes a claim for damages. If you find for plaintiff Louamine Bonnet, she's entitled to recover fair and reasonable compensation for the full extent of the harm and losses caused, no more and no less. Fair and reasonable compensation means to make the plaintiff Louamine Bonnet whole for any permanent or temporary injury and the consequences of that injury or injuries caused by the defendant's negligence. The law on compensation recognizes that plaintiff Louamine Bonnet may recover for any disability or impairment that she suffers as a result of her injuries. Disability or impairment means worsening, weakening, or loss of faculties, health, or ability to participate in activities. The law also permits plaintiff Louamine Bonnet to recover for the loss of enjoyment of life, which means the inability to pursue one's normal pleasure and enjoyment. You must determine how the injury has deprived plaintiff Louamine Bonnet of her customary activities as a whole person. This measure of compensation is what a reasonable person would consider to be adequate and just under all the circumstances of the case to make Louamine Bonnet whole for her injury and consequent disability, impairment, and the loss of enjoyment of life. The law also recognizes as proper items for recovery the pain and physical and mental suffering, discomfort, and distress that a person may endure as a natural consequence of the injury. Again, this item of recovery is what a reasonable person would consider to be adequate and just under all the circumstances to compensate plaintiff Louamine Bonnet. So here are some factors you may want to take into account when fixing the amount of the verdict for disability, impairment, loss of enjoyment of life, pain, and suffering. You may consider plaintiff Louamine Bonnet's age, usual activities, occupation, family responsibilities, and similar relevant facts in evaluating the probable consequence of any injuries you find that she has suffered. You are to consider the nature, character, seriousness of any injury, discomfort, or disfigurement. You must also consider their duration, as any verdict you make must cover the harms and losses suffered by plaintiff Louamine Bonnet since the time of the accident itself to the present time, and even into the future if you find that the injuries and the consequences have continued to the present and will be continuing into the future. The law does not provide you with any table, schedule, or formula by which a person's pain and suffering, disability, impairment, and loss of enjoyment of life may be measured in terms of money. That amount is left to your sound discretion. You are to use your sound discretion to attempt to make plaintiff Louamine Bonnet whole, so far as money can do so, based upon reason and sound judgment, without any passion, prejudice, bias, or sympathy. You each know from your own common experience the nature of pain and suffering, disability, impairment, and loss of enjoyment of life. And you also know the nature and function of money. The task of equating the two so as to arrive at a fair and reasonable award of compensation requires a high order of human judgment. For this reason, the law can provide no better yardstick for your guidance than your own impartial judgment and experience. You are to exercise sound judgment as to what is fair, just, and reasonable under all the circumstances. You should, of course, consider the testimony of Louamine Bonnet on the subject of her discomforts. You should also scrutinize all of the other evidence presented by both parties on this subject, including the records and reports of the doctors. After considering the evidence, you should award a lump sum of money that will fairly and reasonably compensate Ms. Bonnet for her pain, suffering, disability, impairment, and loss of enjoyment of life, proximately caused by Mr. Stubbe's negligence. If you make an award for future pain and suffering, disability, impairment, and loss of enjoyment of life, and you may consider Louamine Bonnet's life expectancy. Her life expectancy at the time of the accident in 2016 was 35.9 years. That's an estimate of the probable length of her life based upon statistical data. And since it's a general estimate, you should use it with caution in an individual case. Louamine Bonnet may live a longer or shorter period of time than the estimated figure, and you should exercise your sound judgment in applying the life expectancy figure without treating it as a necessary and fixed rule. The plaintiff Louamine Bonnet's claim in this case does not include claims for medical expenses. Therefore, in determining the reasonable amount of damages to award Ms. Bonnet, you should not speculate about the medical expenses plaintiff may have had. Also, you should know that a personal injury damage award is not subject to federal or state income tax. Therefore, if you decide to award Ms. Bonnet damages for her personal injuries, you should not add or subtract any tax in fixing the amount of the award. Okay, so let's talk about deliberations for a moment. You are not advocates for either party. You are judges of the facts. Remember that the instruction that I gave you at the opening of the case, that you must not conduct any investigation or research of any nature whatsoever relating to this case. You must not use the internet or any other resource for any purpose at all relating to this case. You must not even look up the meaning of a word in the dictionary. You're to consider only the evidence presented to you in this virtual courtroom and the instructions as to the law that I am now giving you. As I indicated in my preliminary instruction to you, if I determined that any one of you has violated this rule, it may result in a mistrial or a penalty being imposed on the person who violated the rule or fails to advise the court if another member of the jury has violated the rule. Your sole interest as jurors is to determine the truth from the evidence that has been presented to you here in this virtual courtroom in this case. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but only do so after an impartial consideration of the evidence with the other jurors. Since this is a civil case, any verdict of 6-1 or 7-0 is a legal verdict. Therefore, it is not necessary that all 7 jurors agree on each question. Any agreement of 6 jurors is sufficient. All 7 jurors must deliberate fully and fairly on each and every question, and all 7 jurors must determine and vote upon each question. It is not necessary that the same 6 jurors agree upon the answers to all the questions, but whenever at least 6 jurors have agreed to any answer, that question has been decided, and you can move on to consider the remaining questions in the case if it is appropriate to do so. All 7 jurors must participate fully in deliberating on the remaining questions. A juror who has been outvoted on any question shall continue to deliberate with the other jurors fairly, impartially, honestly, and conscientiously to decide the remaining questions. Each juror must consider each question with an open mind, and when at least 6 of you have agreed upon a verdict, the jury foreperson should click on the Ask for Help button in your jury room and wait for the moderator to join you. You will indicate to the moderator that you have reached a verdict and say nothing else. The jury foreperson will submit the electronic jury verdict sheet. Keep in mind that once you submit the verdict sheet, it will no longer be available to you. So what you ought to do is keep track of the answers to the questions in writing so that you'll be able to provide those in open court when we resume. There's only 2 questions, so it's not really that much of a big deal. We prepared a verdict sheet, which I believe will make your task simpler. The electronic verdict sheet will be sent to the jury foreperson by email. And similar to that, the electronic questionnaire, that questionnaire is similar to the jury questionnaire that you received before jury selection began. The verdict form has questions that you have to consider and answer within the framework of the instructions that I'm giving you now. And I will review the questions with you now. When you answer the questions on that verdict sheet, that will be your verdict. You should also know that in the jury folder that you've received, there's another jury verdict sheet. So you can each open the jury verdict sheet and review that question. But for now, I will share my screen. All right, so this is what the jury verdict sheet looks like. Question number 1. Did plaintiff Louamine Bonnet prove by a preponderance the objective credible medical evidence that she sustained a permanent injury that was proximately caused by the automobile accident of June 9th, 2016? What you will do is you will record the vote of either yes or no, and also record the vote count. So you're going to check off either yes or no, and in addition to doing that, you're going to click on this box and you're going to type in the vote count as either a vote of 6-1 or 7-0. If the vote is anything other than 6-1 or 7-0, it's not a valid vote. You need to have 6-1 or 7-0. Now, if you answer that question yes, you will continue on to question number 2. If you answer that question no, you will stop your deliberations and return your verdict. Question number 2 is, What sum of money will fairly and reasonably compensate plaintiff Louamine Bonnet for pain, suffering, disability, impairment, and loss of enjoyment of life that was a proximate result of the June 9th, 2016 accident? What you're going to do in this box is you're going to fill in a dollar amount, and next to it, you will type in either 6 to 1 or 7 to 0. The next page is just the jury foreperson acknowledgement page. There's really nothing to do with that page, and the jury verdict form can then be submitted. Okay. As I said, it's only 2 questions, but that doesn't make it easy for you to deliberate. There are a lot of records that you need to look through, and you will be able to take your time doing that. There's no limit on how long your deliberations can last. We will deliberate today until 4:30 and start up again tomorrow morning at 9 o'clock if you need that much time. If during your deliberations you wish to communicate with the court, or you would like me to repeat any part of the jury instruction, the jury foreperson should click on the Ask for Help button in the breakout room. The moderator will join you in the breakout room, and you will then tell him what the issue is. He will likely ask you to put the question in writing to an email to him, and he'll provide you with his email at that time. When you email him the question, if it is a question, that email will be sent to me. The attorneys and I will reconvene, and I will respond as quickly as I can by having you return to the main courtroom when we're back on the record. I should caution you, however, that at no point until you reach your final verdict should you indicate to the moderator or anyone else what your vote has been on any question before you. That is a matter that only members of the jury should know until you've reached a verdict. So before I send you out to deliberate, let me just take this opportunity to thank you for your service on the jury. We recognize this case has interfered with your daily lives, and thankfully not for a very long period of time. But I'm sure just being here for the couple of days has caused you some inconvenience. But our judicial system could not function without people like you willing to serve on juries. It's a job that has to be done in order that people can resolve their differences by jury trial. And we are extremely grateful for the time that you have spent here on this trial. Do counsel wish to be heard at sidebar?
No, Judge.
No, I don't have any objections to the charge.
Okay. All right. So under our rules, juror number 1 will serve as the jury foreperson. That would be Mr. McCarr. The foreperson ensures that each juror deliberates, writes any questions the jury may have for the court, and then marks the verdict on the jury question sheet. When the jury returns to the courtroom, the foreperson will report the verdict to the court by giving the vote and the answer count to each question on the verdict sheet as they are read by the court. All right, so I'm going to swear the moderator. Mr. Gallinger, raise your right hand, please. Do you solemnly swear or affirm that you will, to the best of your ability, keep every person sworn on this jury together in some private or convenient breakout room, and that you will not suffer any person to speak to them, nor speak to them yourself, except by order of this court, and except to assist when they ask for help from their breakout room, and to otherwise ask them if they have agreed upon a verdict until they have so agreed?
I do.
State your full name for the record, please.
Nicholas George Gallinger.
Ladies and gentlemen, you will now be moved into the jury breakout room where you will be able to begin your deliberations. I will email the jury verdict sheet to the jury foreperson. And as I said, the paper version of that sheet will be in the jury folder for you to access. But the only valid jury verdict sheet is the electronic one that I will send to the jury foreperson, Mr. McCarr. So thank you, and we will await to hear word from you. Okay. Mr. Lavoy,
Yes, Judge. I wanted to, in
I
case.
see your microphone, by the way. It's okay, but you said the other day you didn't want your microphone on the on the
Right, well,
screen.
the jurors aren't here, right?
They're not here.
They weren't. You couldn't see it during any of the testimony, right?
I don't know. I don't think so. Doesn't matter. It just doesn't matter.
Not anymore. I just wanted my client wanted to bring up an issue with you, if you recall.
Okay. All right. Do you want to do that here or at sidebar?
Can we do it in sidebar?
Yes, absolutely.
Great.
Lumine. Oh. Can you hear me, Lumine?
She's on mute.
If you have to go, you can go now. I'll call you.
Welcome back. Thank you. As I understand it, the jury has reached a verdict. Ladies and gentlemen of the jury, as I call out your juror number, I'm not going to state your names, but as I call out your juror number, I will just ask that you unmute and tell me that you're here. Okay. Juror number 1,
Here.
juror number 2,
Here.
juror number 3,
Here.
juror number 4,
Present.
juror number 6,
Here.
juror number 7,
Here.
juror number 8.
Here.
Okay. I would ask that everyone mute yourselves again. And has the jury reached a verdict, Mr. Foreman?
Yes, Your Honor.
Okay. As to question number 1, and I will read the question aloud for you. Did plaintiff Louamine Bonnet prove by a preponderance the objective credible medical evidence that she sustained a permanent injury that was proximately caused by the automobile accident of June 9th, 2016? What was the jury's answer to that question?
Our answer was no.
What was the vote count?
The vote was unanimous.
7-0?
Right.
Yes, I know, that's what unanimous means. Okay. And at that point, did you then stop your deliberations and return your verdict?
Yes.
Okay. Counsel, does anybody wish to have the jury polled? No?
Judge.
Oh, Judge, that's fine.
Okay. Okay, so all right, so the jury has reached its verdict. There is not a necessity to poll the jury, so we can then move on and excuse the jury at this point. I would like to take this opportunity again to thank you for the time and effort that you have put into this. The function that you've performed is one of the most important tasks that you'll ever be called upon to fulfill. With your return to the verdict in this case, your service in this case is now complete. I know that your stay with us has involved some sacrifice at your part, and as I said before, thankfully not a very long period of time, and you did get to do this from home, which is unique in this case. But I trust that when you conclude your service, you should know that you made a meaningful contribution to the judicial process. And I do hope that you've enjoyed the experience. I like to think that when that jury notice comes in the mail next time, that you'll be happy to see it and will be happy to return. You've been serious, attentive, and extremely diligent during the short time that we've been together. And it has been my pleasure to have worked with you on this case. So on behalf of everyone in our virtual courtroom, the citizens of Passaic County, and the entire judicial system, I want to thank each and every one of you because we greatly appreciate your willingness to serve and your service. You are now discharged from service. Thank you very much. You can leave the Zoom hearing at this time. Thank you. Okay. So that being the case, we will then, I'll make the, enter the appropriate order based upon the previous order for the expedited trial in this case. Anything else that we need to address?
I don't think so.
Judge, I just have a, people are asking, do you have any idea when the video of the trial is going to be posted? And then is there any opportunity for people or the parties involved to get their own individual copy of the video?
I'm not aware of a method to get a copy of the video. But I can find that out and I can email you that information back. I have no idea.
Okay. And then also
and as far as availability, it should be available on the court website tomorrow.
And how long would it be up there for? I mean, is it like a limited run?
You'll have a minute. You'll have a minute to get it. No, I'm kidding. I don't know how long they keep it up. I can find that out and I can get back to you with that as well.
I would be fine with a minute run. And then lastly, I have adjusters asking me, is there any opportunity, do you think, in the future in a virtual format for them to be permitted in the, I guess, the Zoom room or the trial so they can watch it live?
Yes, they can request that and it can be granted, sure.
Really? Okay.
Yeah.
Okay. Thank you. I'll tell them.
Okay. Well, thank you. Thank you, everyone. It really has been a pleasure conducting this virtual jury trial. It's been a unique experience, but as we know, we're going to start doing these much more regularly. So I'm excited about that. And I hope you guys are too. So thank you, everyone. And that concludes our trial in this case. Take care.
Made
Thank you,
history.
Judge. Have a
Okay.
nice
Thanks, Judge.
day.
All right. Bye-bye.
Bye.